Did you see what Ruth Bader Ginsburg had to say? She's been listening to this show. I'm telling you, she or one of her, I mean, we're only 3 blocks away from the Supreme Court here. She or one of the people on her staff has got to have been listening to this show, because I've been saying this for years. And it's an uncomfortable thing to say as a progressive and a liberal and a Democrat and an advocate of women's rights, but I believe it's true. And that is, as you know, I can't find anywhere in the Constitution where the Constitution gives the Supreme Court the right to strike down laws. In fact, if anything, I find the opposite. Article 3, Section 2, you can read it yourself. It says that the Supreme Court shall operate under regulated by Congress. Congress shall define how the Supreme Court operates, on within what parameters they can operate. But the Supreme Court, since 1803 in the Marbury versus Madison case, has taken onto themselves the power to strike down laws made by Congress and signed by the president, and thus become the most powerful branch of government. And what I've been saying for some long time is that in Roe v. Wade, that the Supreme Court, by making that decision and making it in as detailed a fashion as they did, inventing the 3 trimesters wasn't invented. There actually are 9 months of pregnancy, but inventing these distinctions between the first, second, and third trimester of pregnancy, and coming up with separate, basically, rules for each of these 3 trimesters within which states can make laws. And that basically you can't outlaw an abortion in the first trimester, and you can easily outlaw an abortion in the third trimester, and it's more difficult in the second trimester, in the middle, and you got to, all this kind of stuff. That by doing that, what I've been saying for years and years and years is that by doing that, the Supreme Court took that out of the hands of the legislature and stopped the debate that we were having in the United States in 1974 about that topic. I remember that time. I remember being in high school and having I was going to say a friend. I didn't actually know this woman personally. I knew who she was. She was in my class. Just one day didn't show up anymore. She got a back alley abortion, a coat hanger abortion, a do-it-yourself somehow, and died of sepsis, died of blood poisoning. I mean, that was not, you talk to people who were in high school in the 60s and the early 70s, and many of them will tell you that story, that, this was not that uncommon. This was just in a working-class neighborhood in Lansing, Michigan. So the debate was being had, and the rich were getting abortions left and right. And in fact, I knew some of those at that time girls, 16, 17, 18 years old, who they called them D&Cs. It was a very common surgical procedure. Oh, I'm having problems with my menstrual period. I'm going to have a D&C and dilation and something or other, cauterization or something. And it's basically kind of scraping out the womb. Well, if you're pregnant, it'll end up pregnancy too. And after Roe v. Wade, all of a sudden there weren't any more D&Cs, and they were like really common before then. I remember. So my point, and I'm openly in favor of a woman making those choices, right? So I believe that abortion should be between a woman and her physician, and if she's religious, her pastor or her God, or her family. But it should be up to her. Now that said, because the Supreme Court jumped into this and said, "No, we're the Lord gods of this country. We're the monarchy. We're going to make the rules." They aborted the debate. And so because we never had a good debate on the topic in the United States, because there was never a general consensus among we the people that we had actually worked this stuff out, the anti-abortion movement was actually empowered by that decision. And here's what Ruth Bader Ginsburg, herself an advocate of a woman's right to choose, said. Ever since the decision, she said, momentum has been on the abortion opponent's side, fueling a state-by-state campaign that has placed more restrictions on abortion. That was my concern, she said, that the court had given opponents of access to abortion a target to aim at relentlessly. My criticism of Roe is that it seems to have stopped the momentum that was on the side of change. And then she goes on to say, and I think that this is a really important point, Roe v. Wade was decided based on privacy, on the Constitution, on Fourth Amendment right, on Fourth Amendment. because the Supreme Court had decided that they could only make laws if it had to do with the Constitution. Back in 1803. So the Supreme Court based this on privacy rather than on women's rights. And this was the beginning of the women's rights movement as well. In 1960 or 61, the first legal birth control was sold in the United States. The first legal hormonal, birth control pill. This finally something that actually worked. And out of that came the women's movement, the women's rights movement, the women's power movement. And frankly, the abortion issue, debate, should have been around the rights of women rather than around the Fourth Amendment and what Thomas Jefferson and John Adams thought, who, were not all that fond of the rights of women. And this is exactly what Ginsburg says. She says, the ruling was also disappointing to a degree, Ginsburg said, because it was not argued in weighty terms of advancing women's rights. Rather, the Roe opinion, written by Justice Harry Blackmun, a man, centered on the right to privacy and asserted that it extended a woman's decision whether or not to end a pregnancy. I just, when I saw this, she told the students she prefers judicial restraint. She said the court can put its stamp on approval on the side of change and let that change develop in the political process. So what she was saying was the court should have, in Roe v. Wade, still voted in favor of Roe, but done it on a very, very narrow basis and leave all that other stuff to the legislature, to we the people, to our elected representatives. And I think had that happened, that we would not here be, 40 years on, 50 years on? How long has it been since 1973? It's 40 years, isn't it? Yeah, count on your fingers. Yeah. 40 years on, still having this argument. The Supreme Court should not be the arbiter of the law of the land. It should be we, the people. It should be the people themselves, to quote Thomas Jefferson. About this issue, by the way, speaking about this issue. When he was asked why did he oppose Marbury versus Madison, he said, because, my construction of the Constitution is very different from that which you state. I believe that, I'm doing this from memory, I believe that each branch, well, actually, I can't do the rest of it from memory. I don't have the whole thing memorized. But he essentially said each branch should be its own, should determine for itself what the Constitution means. And two of those three branches are elected by the people. And so ultimately, it's in the hands of the people themselves to decide what the Constitution means. And that's really been the case. The Supreme Court upheld slavery for, half a century. And then decided to knock it down. I mean, it's just, they upheld apartheid in the United States for almost a century. Supreme Court, with this doctrine, has done so much damage. Anyhow.
You're listening to the Thom Hartmann Program. Visit thomhartmann.com for audio and video archives.
What the Supreme Court also brought us was George W. Bush as President of the United States, maintaining the doctrine of Reaganomics, which is where I started on this rant, and which is what we've got to do something about.